Here's my problem, Counselor. This is where I think you're headed. I think what you want to do on the federal bench is advance a social agenda and rewrite the Constitution every other Thursday to advance a social agenda that you can't get by the voters through their elected representatives.
Senator?
Now, that's a legitimate thing to be for. This is America. You can believe what you want, but you spent your whole career doing that. And it bothers me that you're not defending that here, that you're dodging my questions. Do you think the Constitution should be used to create new rights?
Senator, I think the Constitution is an enduring document and that...
yeah, I agree with you. It's been around a long time. It's enduring. And I'm fond of it. You love it. I'm fond of it too. But do you think it ought to be used to create new rights?
Senator, I think it is constantly being interpreted, and the Supreme Court has, through the 230 years of jurisprudence, has found rights in it.
Yeah.
And if I am confirmed as an appellate judge, I would faithfully apply Supreme Court precedent.
Yeah. But are you going to use it to try to create new rights?
Senator, appellate court judges don't create new rights. They take the record below them.
Sure they do, Counselor. We've both been at this a long time. They do it all the time. And then it goes up to the Supreme Court, and the Supreme Court says yay or nay, or sometimes they don't say anything. Let me ask you this. What barometer should we use to decide whether a federal judge ought to create a new right or the people's elected representatives through a Congress or a legislature? What's the standard you use there?
Senator, we have co-equal branches of government. The legislature does the policy making, the judiciary.
Yeah, but what's the standard? I'm sorry to interrupt you, but we had this problem in the last administration, and we have it in this administration. If you could just answer my question, because 5 minutes just goes like that. What standard do you use personally to decide whether a new right ought to be created by a federal judge or by the United States Congress if it's a federal right?
Senator, I would be applying precedent, and precedent has
I stipulate
standards of
that you're
review.
going to apply precedent. I stipulate that, so let's take that off the table. What standard should be used to determine whether a new right ought to be created by a court, a federal judge, unelected, appointed for life, or a United States Congress?
Senator, appellate courts have standards of review when looking toward lower court decisions, and I would apply
Come on,
that
Counselor,
standard.
you're not answering my question. It's a real simple question, and you're very smart, and you know what I'm asking. You believe in a living Constitution, okay? I get that. That's a legitimate point of view. You say you don't understand what an originalist is, but I don't think you're being candid there. But this is what let me ask my question again. What standard should be used to decide if you're going to create a new right in the Constitution, whether that right ought to be created by a federal judge or the people's elected representatives? Very simple.
Senator, the federal courts are of limited jurisdiction. The appellate courts sit in between a Supreme Court.
Okay, you're not going to answer it. I get it. When you were at the Brennan Center, you're still there, right?
I'm on leave, sir.
Okay, well, but when you were there, did you advocate federal courts create new rights under the Constitution?
No, sir.
You never did?
No, sir.
Okay.
The right to vote is protected in the Constitution, and it's protected.
So you never asked for new rights, you just said they're already there?
Yes, sir.
Okay. How do you know a right's already there if it's not explicit?
In the case of voting?
No, just in general. If I read your resume and it's not, something's on there, well, that's a bad example. If you look at the Constitution and it doesn't, let's say reparations, okay? And it doesn't talk about reparations. How do you know whether a right should be granted if it's not there? That's what I understand you to be saying with the living Constitution.
Senator, again, a case would not come before an appellate court unless parties presented an argument.
I get that. I understand how a lawsuit's tried. let me ask you again. How do you know if a right's not explicit in the U.S. Constitution that it's really there? It's hiding, it's lurking, and we just have never seen it.
Senator, in Marbury versus Madison, the Supreme Court said that the Supreme Court interprets the Constitution.
Right.
I would look to precedent. I would look to see.
What if there's no precedent?
There's always some precedent.
See, here's my problem, Counselor. This is where I think you're headed. I think what you want to do on the federal bench is advance a social agenda and rewrite the Constitution every other Thursday to advance a social agenda that you can't get by the voters through their elected representatives.
Senator.
Now, that's a legitimate thing to be for. This is America. You can believe what you want, but you spent your whole career doing that. And it bothers me that you're not defending that here, that you're dodging my questions.
Senator.
You're not the only nominee who's done that. It happened under the prior administration. It must be something in the water at the White House. But I'd respect you a lot more if you just up front said it.
Senator, I believe in the value of precedent. I think it makes our system.
So do I, but that's got nothing to do with our discussion. We both know that. And I understand that you've been advised to say precedent, precedent, precedent. When in doubt, is it raining outside? Precedent. But it inhibits our ability to have a rational discussion. Thank you, Mr. Chairman.
I want to just pick back up where Senator Tellis left off when it comes to ballot harvesting. This is an issue that the United States Supreme Court has recently taken up in the Brnovich case. You've had quite a lot to say about the Brnovich case. You've had quite a lot to say on quite a number of the Supreme Court's precedents, which you would be called upon to apply. So I'd like to get your views on those. You seem to be fine and perfectly willing to characterize Supreme Court precedent, so I'd look forward to your testimony here under oath. You said that the Brnovich case was a clear-cut case. The Supreme Court ruled, and you actually characterized some of the arguments in the case made by Brnovich and made by various amici in support of Arizona as outrageous and harmful, including a brief filed by my colleague Senator Cruz. So I take it you think the Brnovich case was wrongly decided?
Senator, my views on the Brnovich case are immaterial because if confirmed, I would be duty-bound to apply it, and I would do so without reservation.
Oh, I think they're quite material to get at your judicial philosophy. So let's try again. Do you think the Brnovich case was wrongly decided? You said that the case was clear-cut. The Supreme Court ruled differently than you thought. So I take it you think it was wrongly decided.
Senator, I would apply the precedent without reservation.
Do you think the Brnovich case was rightly decided?
Senator, I would apply the Brnovich case without reservation. It is the law of the land. The country that I care so much about depends upon stare decisis and the application of precedent.
Well, that's not what I'm asking you. I'm asking you about your comments on a Supreme Court case, which you will indeed be duty-bound to apply, but I think understanding your view on that case is relevant. Let's try a different one. Shelby County. You said that the Shelby County case gutted voting rights. So you think that case was wrongly decided. Will you be able to apply that case faithfully?
Without reservation.
Do you think that the Heller case was wrongly decided?
Senator, Heller is the law of the land, as is its application through the states of McDonald. I would apply it without reservation.
Do you think Brown versus Board was wrongly decided?
Senator, I would apply Brown versus Board without reservation.
Do you think Brown versus Board was rightly decided?
Senator, I think it was rightfully decided. And
it was rightly decided. Shelby County was wrongly decided, you say, but you won't say about the Brnovich case, you won't say about Heller. What's the line here? How am I to judge how you're going to apply the law if you won't be frank with the committee about what you've said in the past and about your own views now? I mean, you've been an activist for quite some time. You've commented on many laws. You've called voter ID laws like we have in my state of Missouri, which, by the way, the voters of my state passed directly. The voters passed. You've criticized those as Jim Crow type laws. That's an extraordinary statement for a judge, someone who wants to be a federal judge, not an activist, not a constitutional lawyer, a federal judge. You've called the precedents of the United States Supreme Court, you've talked about them as gutting voting rights. You've criticized them in the harshest of terms. You've done this repeatedly. So I think it's fair game to ask about your view of precedent. So how are we going to know? I mean, let's come back to the Heller case, the McDonald case that followed on from Heller. Was that rightly decided?
Senator, I would apply it without reservation. And if I may say, for the last 15 years have been an advocate when under our system requires zealously pursuing the interests of my clients. A judge plays a completely different role, and by accepting this nomination, I am pledging to this body, to the American public, before my God, that I would faithfully discharge my duties under the Constitution, which require me to put aside any personal policy viewpoints I have and examine what the matter is before me and apply the precedent of the Supreme Court and the Second Circuit. And I do this without reservation. I am willing and able to serve my country in this way.
Do you still think the Shelby County case gutted voting rights?
Senator, as an academic, as a researcher, as an advocate, I have done a number of research where I have been able to lift out and identify instances in which policies that passed that were not likely to have passed had it not been for Shelby County. But Shelby County is the law of the land, and I would apply it without reservation.
Let's talk just a little bit about your broader judicial philosophy. You've been an advocate of living constitutionalism. You said in 2021 that if you are one of those people who think that we were at our best when our country was first founded and didn't include women or people of color or people without property in the electoral process, then this conversation about living constitutionalism is probably not for you. I take that to be a disparagement of originalism. You've also said that the Constitution is not static or frozen in time, but it has to evolve and be dynamic in order to actualize its principles. So is this the judicial philosophy you would follow in cases of first impression? When you don't have a controlling precedent point, you have to construe the Constitution, you would look to dynamic and evolving principles?
Senator, I believe in the conversation that you were speaking of, I was talking about Justice Brennan's definition of a living constitution.
What would be yours?
I believe that we have a constitution that is enduring. I think its great values are applicable and relevant and can guide us today. I think they're timeless, and I believe that they make our country strong.
Do you consider yourself a living constitutionalist?
I don't think those kinds of statements are helpful in explaining the approach that I would take, which would be first examining the text, then examining the precedent. And if I needed to go beyond that, I would be looking at the canons of construction, the legislative history, the structure of what was at issue. And more importantly, I would be bound by the record of the parties that presented the case to me.
Well, my time has expired, so thank you, Mr. Chairman, for your indulgence on this. I'll just say, Ms. Perez, in conclusion, I want to echo Senator Kennedy's remarks that I think given your very lengthy record of statements about Supreme Court precedent, about many court precedents, I think to come to this committee and to refuse to answer questions about those, to refuse to explain your statements, to say you're not going to comment about decisions. You have commented frequently about decisions. I just think that, with all due respect, that's not candid. I think it's frankly not transparent with this committee, and I won't be able to support your nomination. Thank you, Mr. Chairman.